Good afternoon, everybody. My name is Blair Feldman. I am a Social Security Disability Claimants Representative. That means that I represent people who are applying for Social Security disability benefits and who might get denied and throughout the whole appeal process. Today, we're going to learn about applying for Social Security disability, what it looks like, what the whole process looks like, what the definition of disability is, and ways that you can approach your case to hopefully win it. All right, so the first thing that I like to do, and I have this conversation with my clients as well, is to talk about the difference between a couple of the disability programs under Social Security. A lot of times you hear them sort of interchangeably, or people say disability insurance or DIB, SSDI, SSI, you hear all these different things, and sometimes people mix them up. But there are two major programs under Social Security disability benefits. The first major one is called Disability Insurance Benefits, or Title II. And Title II, and this is, if you look at the slide, is on the left side, the left column here. And this is the program for people who have worked and paid in to Social Security. So if you know, every time you have a paycheck from your employer, part of that goes to, you see a part of the taxes coming out of your check go to Social Security. That's like you're paying into an insurance plan. So every time you work and get a paycheck, part of it goes into the pot of Social Security. And eventually, if you become disabled or if you retire, everything that you've paid in through your lifetime of working is what you would get back if you're approved for Social Security disability insurance benefits under this left column, Title II. So Title II benefits, or SSDI or DIB, these benefits, what you get if you become disabled is based on what you paid in. So if you had a really high wage in your lifetime of working, the money that you'll get each month if you're found disabled is going to be higher than if you had a low wage throughout your lifetime working. In Arizona, and just a caveat, some of the numbers I'm going to be throwing out here are based on just an average of what's going on in 2025. So this changes a little bit, but in Arizona, on average, the monthly disability benefit people get is about $1,300. Obviously, it's different in different parts of the country because wages are higher in different parts or lower in other parts. But on average, $1,300. Now, a lot of people ask me, well, what am I going to get? We aren't sure in the middle of a case what you're going to get, but you can look online ahead of time. If you create a My Social Security account at ssa.gov, you can actually go on there and pull up your earnings statement. And if you create an account on My Social Security and click on the earnings statement, it'll give you an estimate of how much you might get if you reach full retirement age, or how much you might get if you become disabled. And that's where you can look for yourself. But when we're in the middle of a disability case, it's everyone's different because their earnings history is different. So I have to either tell you, go to your own My Social Security account and check, or we can wait towards the end of the case when we get to the point of a hearing, and we'll be able to see it then. So again, looking at this left column for disability insurance benefits, you have to, in order to get the disability insurance benefits based on what you paid in, you have to have worked enough and paid in enough. So that means you have to have enough quarters of coverage. This is similar for retirement benefits. So if you have never worked, or it's been a really, really long time since you worked, you might not have enough quarters of coverage paid into the Social Security system to qualify for this benefit. So there's that. One of the benefits to getting disability insurance benefits under Title II is that anyone who's paid in enough and is found disabled can get this monthly amount. And it doesn't matter how much money they have in the bank. There's no resource limit. In other words, you can be a millionaire and have 5 mansions. And if you paid in enough and you're disabled, you can get it. You can get your monthly benefit. Another benefit to disability insurance under Title II is that if you're found disabled, you will also become eligible for Medicare automatically. You'll get Medicare health benefits 2 years after your eligibility date for disability insurance benefits. So that's Title II benefits. The other program is SSI, or Supplemental Security Income, which also is known as Title 16 benefits. This is also a disability program, but it's different in how the benefits are calculated, and all the financial stuff about it is completely different than Title II. So for SSI, it's for people who maybe never paid into Social Security by working. Maybe they never worked, or maybe they haven't worked in a very, very long time. So they don't have, there's no need for showing quarters of coverage under SSI. Instead of the benefit amount, the monthly benefit amount, instead of it being based on what you paid in, because maybe you never paid in, it's just a fixed amount that's designated by the government. Right now, it's $967 for an individual, $1,450 if you're a couple. And again, this is in 2025. That monthly amount changes a little bit each year. It might be raised for cost of living increase. These numbers are for 2025. So that's how much you get. You can't get more. You might get less, and I'll talk about that later, but that's the maximum. And then there is a resource limit. So this is a huge difference. The only people who can get SSI is they have to be disabled, and they have to have less than $2,000 in resources, in assets. And that includes money in bank accounts, cash that you have in hand. They don't count one house and one vehicle, but if you have a second vehicle, or if you have money in a pension account or a retirement account or investment accounts, all of that money they look at, and you have to have less than $2,000 to qualify for SSI. Another difference is that if you're approved for SSI, you don't get Medicare. Instead, you get Medicaid, which in Arizona is access health insurance. So a lot of people are already on Medicaid. Basically, you'll get to keep Medicaid, and it's tied to your designation as getting disability under SSI. So these are the two major programs. There's also some other ones that we're going to talk about in a minute that fall under these, but these are the two major umbrellas. It is possible to qualify and to receive both of these at the same time. And a lot of people, when they apply for disability, apply for both, and you should apply for both just in case if you're not sure which one you're qualified for. Social Security will let you know, but you apply for both. And then if, let's say, you paid into Title II, you worked and you paid in enough to have enough quarters of coverage to get Title II disability benefits, but you worked and your wages were very, very low, and your monthly average benefit, the average benefit that you get would only be like $500 a month, SSI can step in and pay the remainder up to that $967 maximum. So some people actually are getting some money from each program, but the most you can get is the largest one. So if the larger one is SSI, you're only going to get $967. On the other hand, if you qualify for both, but then your disability insurance benefit is $1,200 a month, that's obviously more than the $967 SSI max. You can only get the bigger one. So you'll only actually end up getting the SSD in that case. Okay, moving along. There are some other disability benefits. You might have heard of disabled adult child benefits. Disabled adult child benefits is a Title II benefit, so a disability insurance benefit for people who became disabled prior to age 22 and continue to be disabled. They can get benefits even if they've never ever worked on their own and therefore never paid in and don't have those quarters of coverage. They can get disability insurance benefits based on one of their parents' earnings records, if the parent also becomes eligible either by retiring, being disabled, or dying. So this is a great situation for children who never are able to work, never will be able to work. They've been disabled potentially their whole lives. Instead of being stuck with that SSI, the lower SSI amount, they'll actually, what they get is 50% of their parents' monthly benefit. If when the parent is still alive, or when the parent dies, it bumps up to 75% of the parent's monthly disability benefit or retirement benefit. And that often is higher than SSI. And they also will get Medicare, just like any Title II recipient. One key caveat is that a disabled adult child must prove they're disabled before age 22 and ongoing forever to keep entitlement. There's some things that could kick them off of it, like getting married, unless the person they're marrying is also a disabled adult child, or if they do work and it ends up being substantial work, therefore proving they're not actually disabled ongoing. Again, it has to be a continuous period of disability from pre-age 22 forward. So that's what a disabled adult child benefit is. Other disability benefits are child SSI. So this is for children who are disabled. Obviously, children have never worked and paid into Social Security. So there is no such thing as Title II benefits for kids. The only thing that there is SSI. There's special rules about what disability means for children, and I'll get into that later, but basically they have to meet very specific criteria. And the other trick is for children, even who very clearly meet the disability criteria, there is, it's only SSI and there is a resource limit. So just like for adults, the resource limit is $2,000. You can only have $2,000 in assets and resources to qualify for this. For children, there's a family resource limit. There isn't one number that I can tell you, because the resource limit number is actually dependent on the whole composition of the family, how many parents there are, how many parents are wage earners, how many children in the family are disabled. So there's a whole calculation, and it depends on each different case what that is. But basically they look at that, and that's the resource limit. Unfortunately, if you as a family are above whatever that resource limit is, then the child isn't eligible for the SSI benefits. When a child turns 18, if they've been disabled throughout their whole childhood, at age 18, sometimes some children automatically, depending on their condition, can start getting disability as an adult right away. Others go through age 18 redetermination process, and Social Security will look, is this child, now that they're turning into an adult, are they still disabled? Or when looking at the adult rules, are they maybe not disabled anymore? So let's move on to what the definition of disability is for Social Security. I'm going to talk to you about what it is first for adults. For adults, this is what it says. I put on the slide here. This is what the law says, just copy and pasted. The law defines disability as the inability to engage in any substantial work because of a medically determinable physical or mental impairment. So either a physical or mental condition, or a combination of both, which can be expected to either result in death, or which has lasted at least, or expected to last, a continuous period of 12 months. So basically what this means is to boil it down, a disability under Social Security is a disability that that's going to at least last 12 months, or expect to end in death, like a terminal illness. And it has to be a disability that's so disabling that it prevents you from doing any sort of substantial, full-time, regular work. I'll give you some counter examples. Some counter examples are someone who gets in a car accident, is in the hospital in a coma for 3 months, then they get out of the coma, then they start doing better, and then miraculously they're better in 9 months and they're able to go back to their regular job 9 months later. Well, you could say, well, that person was clearly disabled for those 9 months because of how bad their condition was. But for Social Security purposes, they can't get disability benefits because it has to have been at least 12 months or more. You don't have to wait to file disability you don't have to wait a whole 12 months of being disabled and being out of work for 12 months, but your condition, it has to at least be expected to last 12 months or more. Obviously, an exception is, like I mentioned earlier, for people who may be diagnosed with a terminal, let's say stage 4 cancer, where they are, their doctor says you have 6 months to live. Obviously, that's not 12 months, but because it's a terminal illness expected to result in death because of it, then they do actually allow disability for those types of cases. For children, it's different. The definition of disability for children doesn't have any work component. Obviously, no one's saying, can a kid work? And whereas with adults, the issue is, can someone do their past work or other work? For children, it's just purely, what medical condition do they have and how bad is it? For children, they have to meet certain very specific, severe disabling conditions, and there's very specific criteria for those, and I'll explain that a little bit later, with the same duration requirement that it has to be either expected to end in death or a continuous period of not less than 12 months. Let's talk about the application process. The application, you're saying, okay, I think I meet this criteria for disability. What do I do? The first thing you got to do is apply. You can either apply online through the Social Security's website, ssa.gov, and I put it on here so you can see that, or you can go in person Social Security office, although that's kind of in flux right now. They're asking people not to go in person, so I don't recommend that. I think very few people, limited people, can do that, but for the most part, they want people to do it online and also by phone. You can call 1-800-772-1213. That's anywhere in the United States. You can call that number and ask to set an appointment to do the application process over the phone, and they'll walk you through it and get it all processed for you, usually within 2 weeks or so when you call them. So you do the initial application. Once you finish the application, it takes, usually about 9 to 12 months, then you get an initial decision. That's called the initial decision happens, you get denied. You have 60 days to file an appeal. That's called a request for reconsideration. Then the next appeal, if you get denied again, you have a request for hearing. Then you go to a hearing. If you're denied again, then there's the Appeals Council, which is a panel of judges in Virginia that oversees the administrative law judges' decisions if you decide to appeal it there. That's all within the Social Security Administration. If you lose at the Appeals Council level, there are further appeals you can do, but it's a little bit different because you're moving outside of the administration. And at this point, you have to file a lawsuit, filing a lawsuit against the United States of America, against the administration at the US District Court, asking for a federal court judge to review the case and make a decision. From there, in theory, there's appeals that can be done further to the Ninth Circuit and then eventually the United States Supreme Court. With regard to the initial application, again, I just said, you can go online, you can do it by phone. And as I said, in person right now is currently suspended, but it's sort of a moving target. So if you're a type of person who you really feel strongly about going in person to your local Social Security office, you can give it a try. They might just hand you a little pamphlet that says, call us, but you can try if you feel really strongly about it. I recommend that you try doing things online and by phone. They ask you biographical information when you file the application. They ask you medical information, especially the names of any doctors that you see, hospitalizations, that kind of thing, the name of your medications that you're on. And then they will ask you about 5 years of your work history. The application, if you do it online, you could really get it done in about an hour. and you submit it. Then Social Security will send you things in the mail to sign, and then they'll start processing your application. The initial determination process is handled in Arizona by the Arizona Department of Disability, or the Disability Determination Service in Arizona. Because it's a federal program, though, if Arizona's really backed up, they might ship your case or a huge batch of cases out to another state that maybe has more time. And it doesn't really make a difference to you or to anyone. It's a federal program. So really anywhere in the country, they do the same thing. It's just a matter of who has your paperwork at hand. But that wouldn't make any difference to you. You just might see that you get some mail from Utah or California. It doesn't make a difference. It's just where they're sending you mail from. They will send you lots of forms to fill out about your daily functioning, follow-ups on, new medical providers, things like that. They might send you to doctors to have examinations done. Those are called consultative examinations. We call them CEs. They have people who do physical consultative examinations if you have a physical disability. They also have psychologists who do mental health ones. This initial determination process takes about 12 months. And in that 12 months, that's what happens. So eventually you get a decision. And this is just, an average estimate nationwide, about 70 to 75% of cases get denied initially, even completely valid cases. Maybe it's because they didn't get the evidence they need, or, there's a whole host of reasons why. But if you get denied, what do? The first thing you have to do is know that you have 60 days to file the appeal from the date of the denial notice. You can file the appeal online. You can go to Social Security's website again and file the appeal there, or you can also get the appeal form and mail it into Social Security. If you do that, I recommend you send it certified mail with a return receipt so you have proof that you filed it. If you do it online, there's a confirmation page that you can print and save, and I recommend you do that too. So the first appeal is called a request for reconsideration. It takes another 4 to 6 months to get another decision. A different team at the DDS office will look at your case again, look at new medical records, maybe send you to doctors again, fill out more forms. If you get a denial notice upon reconsideration, the next step is to file, again, you have 60 days to file the appeal. The next appeal is a request for hearing to have your case go before an administrative law judge, which is just, or we say ALJ. That's just a term for the judges that we have in the Social Security Administration. Excuse me. So at that point, you requested a hearing. Usually it takes about another 4 to 6 months for that hearing to be scheduled. Although they do give you about 75 days advance notice. So you're going to know about when the hearing is in with a lot of time ahead to prepare. You'll get to give your preference about how you want to have your hearing. Ever since the COVID pandemic, they switched hearings. They used to be all in person at the hearing office locally. Now you can choose to have your hearing by phone, by video using Microsoft Teams, or you can still choose to do them in person if that's what you want to do. You give your preference. Right now, phone is the default. And I've noticed in my practice that there isn't really any difference in, who wins, or how many, if cases get approved or denied based on how the hearing, if you choose to do it by phone or video or in person, it really doesn't make a big difference. So a lot of my clients like to do it by phone or by video because it's, they don't have to go in person to show up to court, which can be very stressful or a really long drive. So we do a lot of them by phone. Okay, the hearing. And what does a hearing look like? Well, when it's in person, you're in a room. You're not in a big courtroom, like the kind of courtroom you might see on TV, or maybe that you've been to for, a parking ticket or something, something like that. It's different. They're private hearings. They are private because this is protected medical information. Your case is about your medical condition, so they're governed by privacy. They're not made public. They're never published anywhere, anything like that. at these levels. So the hearings are in Tucson. It's in an office building. You go into a private room. The only people in the room are the judge's assistant, who is just there to make sure the technology is working, and you and your attorney, if you have one. There is not an attorney on the other side. These are considered non-adversarial hearings. What that means is you don't have a lawyer from Social Security arguing against you. The judge asks sort of as the neutral arbiter of the hearing, but also somewhat of protector of benefits. And, it's their role to decide whether you meet the criteria to receive disability benefits. There are also witnesses that are called. Almost in every hearing, there's a vocational expert or jobs expert who testify about your past work and what jobs exist that people can do and not do, depending on their work limitations. The judge might also call a medical expert, and or one or more medical experts. You or your attorney might ask to have a friend or family member testify as a lay expert. Or a lay witness, excuse me. So there's different people who testify. And then of course, the person who is the claimant, the person who is alleging disability, also testifies as a witness. So that's what that is. If anyone here is an attorney who practices in a different area of law and is interested in this, there's no such thing as discovery, where you don't have rules where you have to where both sides are forced to show their cards, show all of their, their position ahead of time. We don't follow the evidentiary rules of most courts do. We have a different set of rules that's governed by Social Security that says when you need to have your evidence in by 5 days before hearing. There are rules about it, and you have to give all evidence, favorable or unfavorable, to the judge to consider. But other than these special rules that Social Security is governed by, we are not governed by the typical evidentiary rules that maybe the superior court has to follow. What happens next? So you go to hearing. There's a few options that you can, and you get a decision. You might get a fully favorable decision. If you get a fully favorable decision, that means that the judge agrees that you're disabled all the way back to when you said you were disabled. That means it's 100% favorable to you. It'll get sent also to the local office and the payment center, and they will process a notice of award spelling out how much your monthly benefit is, how much back pay is. Social Security's, if it's an SSI case, they might call you on the phone to ask you about your financial situation and make sure you still qualify for SSI. And those are the types of things that you will get after a fully favorable decision. It's possible that you might get something called a partially favorable decision. A partially favorable decision is one in which the judge maybe agrees that you are disabled, but says that the beginning or the onset of your disability is different than the one you said. So let's say you said, well, my alleged onset date, my AOD, is January 1st of 2020. And the judge, after looking at all the evidence and talking to you, says, yeah, I think you're disabled, but I don't think you became disabled until January of 2022. It's still favorable, but that's considered a partially favorable decision. And then finally, of course, an unfavorable decision is one in which the judge, after going through the whole hearing process, decides that you are not disabled under the rules. And if that happens, then again, you have 60 days to file an appeals council request for review, where you ask the appeals council, that panel of judges, to review the judge's unfavorable decision. That is done wholly by writing. You can submit additional evidence and legal arguments. You don't actually physically show up and go to court, though. Okay. The next thing I am going to talk to you about is the 5-step sequential evaluation process. So this is the process that the judges, this is the sequential evaluation that the judges go through when they're making their decision, and even at the lower levels when they're making the decision at the beginning parts of your case. It goes in order. So the first step is substantial work. Are you doing substantial work? That's a term of art. that means that, and this changes, but in 2025, substantial work means earning $1,620 a month gross pre-tax, okay, earnings. If you're earning substantial work, then you are not qualified for receipt of disability benefits, even if your condition is really, really bad. If you're able to earn substantial $1,620 a month, then you cannot move on. You'll just get an automatic denial. They won't even look at your medical records, okay? Let's say you're not doing substantial work. Then the next thing they do is look to see, do you have a severe impairment? A severe impairment is an impairment means a medical condition that affects you, and it has to be severe. In other words, you can't just apply for disability because you have high blood pressure that's completely under control with your medications. Okay, that's not severe. It has to be severe enough that it affects your ability to work. Okay, at least minimally impact your ability to do work. So as long as you do have one of those, you have a severe impairment, and you might have many, at least if you have at least one, then they move on to step 3, which is, do you meet a listing? And I will get into this in detail in a minute on our next slide, but a listing is a literal list of different types of conditions that you might have that are so severe that if you meet all the criteria, you automatically are found disabled if you meet them. Okay. So at step 3, you might, if the judge or the determiners below find that you meet the criteria of a listing, you could win your case right then and there. But if you don't meet a listing, then they move on to step 4. Step 4 is where they determine what your residual functional capacity is, or RFC. And they say, and what an RFC is where they say, okay, how much can you lift, sit, stand, walk, use your hands, use your legs, use your brain, you know, are you able to work with people? Can you work in a loud environment? All the things that you're able to do or you're not able to do, they put together in this residual functional capacity. And with that, they say, as step 4, given all of those limitations, are you able to do your past work? And if they say, yes, you could do your past work, then you lose. However, if they say, no, you're not able to do your past work, then they move to the final step, step 5. And step 5 is there any other work out there in the whole national economy that you could do? And if the answer is yes, there are some jobs that you can do with all those limitations, then you lose. But if this answer is no, there are no jobs, not even the simplest job, easiest job, physically, mentally easy job that you could do out there, given all of your limitations, then you are disabled. So I told you I was going to tell you about the listing of impairments. So this is it's also known as the Blue Book, you may have heard of. Some people call it the Blue Book. We attorneys and judges, we call it the listings of impairments. They are categories that are broken down into categories of all the different body systems. So if you look here, 1.00 is the musculoskeletal disorders, 8.00 skin disorders, 11 neurological disorders, 12 mental disorders. I'm going to show you an example of listing 1.15, which is under the musculoskeletal disorder umbrella. And this is the disorder of the skeletal spine resulting in the compromise of a nerve root. So this looks, it's a kind of a messy slide because there's a lot of different criteria that are listed here. And I wanted to show you this because you might have a spinal injury, but it has to meet through the medical records all of the conditions, all of the criteria listed on this screen to meet this listing. So it has to be very well documented and very severe. And a judge or the lower levels at the agency aren't going to just take your word for it that you meet a listing. It has to be well documented documented in objective evidence through your medical records and your doctors who explain and show through MRI and everything else and physical exam that you meet these listings. Okay. Another listing that I have an example, this is a mental listing. This is the listing for adults for autism spectrum disorder. Again, this one, this is it seems a little less busy here. You have to have medical documentation, usually through psychological testing, of qualitative deficits in verbal communication, social interaction, nonverbal communication, and significantly restricted patterns of behavior, interests, or activities. And then you have to have extreme or marked limitations in these different areas of mental functioning. Again, this is, you're not going to meet a listing just by having you or a friend or a family member say, oh yeah, I think this, I think I have all these issues, or I think my family member has all of this. It has to be from a doctor, from a usually, a qualified source, either an MD or a PhD, and someone who treats you and sees you. So that's what the listings are. It's a lot harder to meet a listing than it might look. So most people don't win their cases at the listing level unless it's just very, very blatantly obvious, like the most severe cases. Most people fall into the next category, which is they move on and to see if they're disabled because they can't do their past work or any other work. That's where most people fall into. And this is an example of a residual functional capacity, or RFC, that a judge wrote in a decision that I had. And so I just copied this from a decision. So this was what a judge wrote. After careful consideration of the record, I find that this person has a residual functional capacity to do light work. Light work means lifting 20 pounds occasionally and 10 pounds frequently. But except he can occasionally climb stairs and ladders. He can frequently balance, stoop, and crouch. He can occasionally kneel and crawl. No overhead lifting with the right upper extremity, the right arm, and only do lateral to the side reaching with the right arm frequently. That's because this person had a right shoulder injury. He can only occasionally have exposure to heights, moving machinery, loud noise, temperature extremes, and vibrations. And then he can understand, remember, and carry out simple job instructions only, with only occasional interactions with the public and coworkers. This person had a combination of disabilities. They had a right shoulder injury, but they also had a mental health impairment that impaired their ability to do more complex tasks or handle interactions with people. So this is an example of all the limitations that the judge put together after looking at all of the medical records. And then with that, the judge goes to the vocational expert and says, given all of these, could this person do their past work? And then if the vocational expert says no, then the judge says, are there other jobs out there that this person can do? Okay. There is another little tiny section that I like to point out, and this is, they're called the grid rules, and these are for people who have physical impairments only. This doesn't apply to people who have a mental disability. It's for people in older age categories, and for Social Security purposes, that means generally over age 50, and then at 55, and then at 60. There's special rules. And I'm going to show you if, for example, and I like to give a most obvious example. Let's say you have someone who has an 8th grade education, never went to high school, who has done construction work their entire life, really heavy labor, and then they become disabled to the point now where all they can do is a sitting down type of activity. Well, for that person, we have a special grid that we can use. And the special grid looks like this. If you look at the top, let's say that they're 60 years old now. That's considered advanced age. So we're looking at the screen and we say, okay, they're advanced age. And then if you look at the second column, okay, education, limited or less, they don't have high school. And their previous work experience was unskilled. It was labor work. We look over here and all the way to the right, we see disabled. So we go check, check, check. This person is disabled just based on their age, their education, their past work, and the fact that they're now limited to sitting down only. So in certain situations, we can use age. They do take into account age and your past work and your education and what you're limited to making these findings. Okay. All right, some other common issues that come up in Social Security cases. These are usually what happens once you've already gotten disability benefits. Sometimes, and we see this a lot, people get disability benefits and then maybe go back to work, or the amount of benefits that they were paid, maybe they went over their $2,000 resource allowed amount, and the people even told Social Security, but Social Security took a long time to get their act together and figure it out. They come back to the person and say, you have an overpayment, which means we paid you too much and now you owe us back. Other issues that can happen is you get on disability. It's very common, usually between 1 and 5 years, for cases to be reviewed to make sure that person still meets the disability requirements. And so the Social Security state agency, usually just at random every 2 to 5 years, flags a case and says, okay, I'm going to look and see if they still qualify. Other people, when they're approved for disability by a judge, the judge even says, I'm going to give you these disability benefits, but I think that you're going to improve possibly with new treatment. So I'm going to put a flag on the case for you to be reviewed in 18 months. So this happens, and they're called continuing disability reviews. It's easier to stay on disability than it is to get it the first time. However, you do have to prove you're still disabled. So you still have to keep going to doctors, tell Social Security, here are the names of my doctors, look, I'm still getting treatment. It could also be triggered if you're doing work and you're getting close to that substantial amount. That might trigger Social Security to look in on your case. And then another issues are award discrepancies. For example, if you were getting workers' compensation insurance benefits at the same time as, and then you get approved for Social Security. Social Security is actually supposed to reduce how much they give you based on your workers' comp amount. It's called an offset. So there's sometimes, that issue happens and you might want to appeal it if they did the calculation wrong, or maybe the judge or the state agency said you're disabled, but said you're disabled at a different date than you think you became disabled earlier. That's another thing you could appeal. Or finally, for SSI, let's say you're living on your own, but so the people who calculated your SSI say, well, we think you're living with someone, so we're going to reduce your monthly amount. Again, if Social Security is wrong, you can appeal it. So there are things that you can still, you might get a favorable decision, but things might happen afterwards that come up. Overpayments is something that I see all the time. Most attorneys in practice and private practice, like I do not represent people in overpayment cases for a lot of reasons. They're a huge hassle. Social Security does a very bad job at working with representatives on these, and usually we get cut out of the loop. And then frankly, we don't have a way of getting compensated the way we do in regular disability cases. So most attorneys don't take overpayments. I do on a very limited basis, usually if it's my own client and there was something that happened along the way. But even those, it really is it depends. So most people are handling overpayments themselves. And if you are hit with an overpayment, you have a couple options. You can file an appeal called a request for reconsideration saying, I don't think there was an overpayment at all. Or let's say you look and you say, yeah, actually they did overpay me. But I can't pay it back. I can't afford it. Then you request it to be waived. And there are special forms about that. In order to get an overpayment waived, you have to be not at fault in incurring it. In other words, you have to have done all of your due diligence along the way in telling Social Security about your income and stuff like that. And you also have to prove that you're unable to pay it back. And it would be against equity and good conscience for them to force you to pay it back. Another thing you can do is work with Social Security to reduce the rate of repayment. So if you agree there's an overpayment, let's say it's $10,000 you have to pay back, instead of paying it all back in one, you can actually say, okay, can I pay it back $100 a month? And they just take it out of your monthly check. So that's an option. Talked about continuing disability reviews a little bit, but again, this is if you're on disability already. Sometimes they will say you are not disabled anymore if you return to work and you're working too much, like over substantial amounts, which again is 1620 right now. Or they might say, well, you have medical improvement. This happens a lot when, and I'll give you an example of medical improvement, when someone maybe first got allowed for disability, was approved for disability because they had cancer, and they were automatically approved right away because of their cancer diagnosis. But then luckily through treatment, they got better, and their cancer diagnosis, now they're in remission. Well, they might look, Social Security might look and say, well, they don't meet the cancer listing anymore. They're in remission, so we think they're not disabled. So they send a notice saying we're terminating your benefits, or the notice of cessation is what they're called. What happens, I see people who come to me and say, well, it's true that my cancer's in remission, but because of all of the chemo that I did and the radiation and all these drugs that I still have to be on, I now have neuropathy, or numbness and tingling in my hands and my feet, and I have a lot of fatigue, and I'm still not able to work. We usually end up having to appeal those just like a regular disability case, because the reason the person's disabled is different from the reason that they were originally approved for. We still have a lot of luck with those, but it's more of a fight if the reason for disability is sort of morphed over time. Again, award discrepancies, I talked about this before. This is offsets, usually for workers' comp is the biggest one, although there's some other things like OPM if you're a federal employee, where if you're getting workers' comp benefits from a private workers' comp insurance company, you can't get the full amount of both workers' comp and Social Security usually. If you're on both, usually what they do is the most you can get is 80% of the worker's average earnings when put all together. So Social Security will reduce how much they pay you to get to that, whatever that 80% amount was. And sometimes they do this wrong, or they didn't get the amount, they don't, the amount that you're getting under workers' comp changes, and Social Security didn't know about that change. So sometimes you might need to appeal the notice of award that you get, once you win, because maybe the offset was calculated incorrectly. Again, onset date, we already talked about that. If the date that you said you became disabled is different than the one that Social Security finds, you can choose to appeal it or not. You might not always want to, even though you might get more back pay. It might throw your whole decision into question if you appeal the onset date. So there's sort of a risk analysis there that you have to do. Sometimes it's worth it though. This is where having an attorney to guide you is important. And then also remember, we talked about SSI. The maximum amount right now for SSI that you can get in a month is $967. That's if you're living by yourself and you're on SSI and you get the total amount. However, if you're living with someone who's providing you food and shelter and you don't have to pay them rent, let's say you're living with a friend or family member and they're covering you, and they're just really nice people and they just don't make you pay rent or whatever, you will get your SSI monthly benefit reduced by 1/3 for getting that special living arrangement. So sometimes Social Security does this wrong too, where you are actually paying your family rent, and you should, if you're paying them rent, you shouldn't get that 1/3 reduction. So you want to look out for that too in the award to make sure they're doing that correctly. One thing I like to always mention is long-term private disability insurance. This is different from Social Security. It's a completely separate area of law. If you, through your employer, or maybe you just bought it yourself, a policy through, I don't know, Broadspire or the Hartford, through your employer, that if you became disabled, they pay you like just a regular insurance plan, a monthly amount because you can't work anymore. Usually those policies have a clause in their contract that says if you get payment from us every month, you have to file for Social Security. And if you get it, you have to pay us back for whatever we've paid you for any month that overlaps where you're getting both. And I always like to point this out because people get really frustrated about this, but unfortunately it's in the contract that you sign to get the money from them, and there's nothing you can do about it. They force you to apply for Social Security, and then when you get it, you have to pay them back. So it's just something to keep in mind, that you might, this might happen if you get these benefits. And then I always like to talk about what it means to hire an attorney. And this is what I do. And there's other people in all around Arizona who do this. I practice, I'm in Tucson, Arizona, but I take cases all over the state of Arizona and sometimes even outside of Arizona because it's a federal practice, a nationwide practice. And I'm barred federally, and I can take cases across the country and do this work everywhere. So attorney representation, it's optional. You can go through this whole process by yourself without an attorney. However, and I know I'm a lawyer, so I'm biased, but I strongly recommend you do, because frankly, there are thousands of pages of rules and regulation that govern these benefits. I know I've sort of narrowed it down to a 1-hour presentation today, but I have been doing this for almost 15 years, and it is still surprising. There's new things that come up every day. So it's a vast area of law, and things change constantly. Obviously, then at hearing, there's just certain skills that include brief writing, oral arguments, cross-examining witnesses, that kind of thing that come up. Okay. The way that attorneys get paid in this area is mandated by Social Security. So all attorneys who do this area of law get paid in the same way. And it's called a contingency fee. That means we only get paid if we win. We get 25% of any back pay that's awarded to you one time, capped off at $9,200 right now. That's the fee cap this year. And again, that's only if we win. So if we don't win your case, we don't get paid at all a fee for working on your case. Okay. There's different companies or different firms might charge small out-of-pocket amounts for their out-of-pocket expenses, but everyone does that a little bit differently, but they're usually pretty minimal. So really anyone, there's no such thing. You don't have to pay like a retainer or an hourly rate to talk to your attorney or anything like that. It's affordable for anyone to have an attorney in this area. And they set that up on purpose so that people who can't work and are trying to get these benefits can absolutely afford really good representation. I do like to say there's different types of levels of representation. There's big companies who do these that you might see on billboards or on TV that have people who are actually non-attorney representatives do these cases. I recommend always that you find someone local in your area who does cases. And by in your area, I mean, in your state, just because they might know the issues a little more, a little better and tailored to you.